On Monday, the Constitutional Court will hear the application by former President Jacob Zuma to have his 15-month sentence rescinded. Meanwhile, in an attempt to avoid serving a 15-month jail term, the former president filed an urgent application to have his arrest order stayed at the KwaZulu-Natal High Court on Friday, 2 days before he was expected to hand himself over to start the sentence. This application was dismissed. Zuma argued ill health and old age place him at a higher risk of exposure to COVID-19. The Apex Court is set to hear further arguments on Monday. Meanwhile, the Zondo Commission has filed an application to have Zuma's rescission application dismissed with costs. Will Zuma come out tops? What are the odds? We're joined by Advocate Mosima Rasesemola, Director at Mosima Legal and Lecturer at Tshwane University of Technology. A very good morning to you. Thank you so much for your time. Not much optimism has been expressed by several legal experts when it comes to the Jacob Zuma's rescission application to the Apex Court. Which way are you standing on as you assess what we've seen over the past few days and what's playing out in the courts?
I think, thank you very much for having me. I think the best basis for sort of giving a prediction on what will probably happen should be based on the exchange of papers that has occurred to date, being the application itself to rescind the order, but also a reply by the Commission and Acting Chief Justice Zondo in his representative capacity as the chairperson of the Commission. And I think thus far what we have seen play out in the papers themselves is a variety of discussions, even in terms of like an academic analysis of the case itself. The first issue being that of bringing up the case of former President P.W. Botha and sort of his own style of refusing to appear before a commission and the type of sanction that was charged there. Where some say that, you know, it's not necessary to sort of have that kind of nostalgia and reflect back on what happened at the inception of our democracy, that there's a higher standard that should be brought up, and former President Jacob Zuma should oblige to that. But I found that the heads of argument by the Commission were relatively interesting and quite strong, because the main issue also is to say that, but was former President Jacob Zuma really absent from the proceedings, as he seems to imply? But secondly, to say that, was there really an error in law by virtue of the court prioritizing, in his own words, prioritizing judicial authority, protection of judicial authority over protection of his own fundamental rights? So if I were to look at that and how the heads of argument by the Commission dealt with it, I mean, I can't speculate, but I'd say that they mounted a relatively good argument against the rescission of the order.
Judging from his replying affidavit that you speak of, Advocate, the former president has not ruled out any further action before the Apex Court. What could that essentially look like?
He has not done what?
He hasn't ruled out any further action, you know, that he will be taking before the Apex Court.
I mean, I don't think it's a problem if he were not to rule it out. It is absolutely his right to do that. I've heard talks that the matter would be taken to the African Court of Human Rights. Mm-hmm. And funny enough, he raised the principle of subsidiarity that states that there are certain courts that should be given room to adjudicate on a matter, when he was crushing the issue of the Constitutional Court dealing with this case, to say it should have been dealt with by a high court or even a magistrate court as it pertained to provisions of the Commissions Act, and not that there should be an order of the Constitutional Court. We've seen that the African Court of Human Rights and even other courts in Europe always raise the principle of subsidiarity to say that certain cases should be dealt with by the member states themselves and not so much, you know, the African Court of Human Rights. So I'd say that the very same principle that he raised in these papers could be raised by the African Court, and it possibly might not even hear the case to start with.
You mentioned errors in law, and I suppose as we look to the outcome of tomorrow's judgment, the spotlight is on the application of rescinding. Is it really as simple as saying, I don't like the judgment, so I'm going to rescind it?
Absolutely not. If it were that case, I don't think most court orders would be respected to start with, right? So the first issue that he sort of argued in his paper, former president, was that he didn't respect the orders because he didn't think they were lawful. And this sort of point came across in most of the statement that he issued to the ConCourt, which was in essence denouncing on the first order that was issued in January, and even this latest one that is the subject of these proceedings, right? So there was that sort of tone on his part. And I think the heads of argument by the commission dealt substantively with that, to say, by the mere fact of not thinking an order is correct does not mean that it is incorrect. If anything, like Justice Kampepe had said in her judgment, you could have entered an appearance to some extent, to try and express your view in terms of how you feel we shouldn't go ahead with the sentence, as it were, but also to deal extensively with the application that was made by the commission itself. I think at the end of the day, what the main issue is with regards to this judgment is an issue of interpretation. On former President Jacob Zuma's part, he says, but it's not that I don't respect the courts. I just have very strong opinions, and I have a right in terms of the Constitution to express those opinions. And then in terms of, the court and the commission itself, the issue, but you are displaying disdain for the courts, and we have a right to enforce our own orders. So it's also an issue of interpretation that is clearly spilling into the public domain also, to say, but what exactly happened? Is this an assertion of judicial authority at the expense of a person's fundamental rights? Or is it really the judiciary and the courts, in essence, protecting the Constitution and asserting its power and authority, rightly so?
And in those papers, commission lawyers are saying that the former president's criticism of the commission in his application was essentially self-serving. And they've also, ironed out the tone that has been used here. I mean, you say that the former president is saying that he's not essentially disrespecting the courts, but the use of language and the tone is something that stands out.
I mean, I read the reply, not the answering affidavit, but the heads of argument by the commission, and at some point they even said it's your disrespect. It's veiled. It's thinly veiled disrespect for the courts. And I mean, the prevailing argument that started with the Nkandla judgment is absolutely that. There even, authors such as Mango, when he deals with the issue of separation of powers, to say, put former President Jacob Zuma squarely in the spotlight, and do an interpretation, in essence, of his tone of when he engages the courts. And the issue of separation of powers that sort of is usually conjured up, to say, but is he right in his style of criticism of the court? And I think to a large extent it has to do more with who he is, because a lot of South Africans do criticize the courts on a regular basis. But now that it has to do with a specific set of facts, I suppose, that's when that the court will take it into consideration and can judge the tone accordingly, So I think it's up to the court at the end of the day to make a decision on whether that is a form of disrespect. And I think the court was pretty clear in its earlier judgment a couple of days ago, on the 29th of June, that it interprets that as a form of respect. But the same court came in the minority judgment to say, be that as it may, we think a person's fundamental rights should still be protected, no matter how scandalous his commentary has been outside of the court.
Speaking about outside of the court, Advocate, we have seen the riots that have been taking place across the streets of KwaZulu-Natal. Protesters there, supporters of former President Jacob Zuma, saying that they will not stop until the former president has been released from prison. How much of an impact will that have, or could it have, on the outcome of the ConCourt tomorrow?
That is purely based on whether the issue was sort of raised in the papers or not. So from a reading of the founding affidavit, there was never a reference that was made to that. What I've only seen is that there are a lot of sort of people making commentary outside of the court to say, but this should have an impact. But from a constitutional review or analysis, constitutional theory perspective, on the one part, you have the concept of constituted power that is vested in institutions to protect the Constitution or to realize the Constitution. And I think the Constitutional Court judgments in themselves are one of the purest expression of a protection of the Constitution. They never hold back on how the Constitution is supreme and should be respected. But by the same token, with public protest, there comes a question that's been happening among some colleagues to say, but is this a type of constituted moment, a type of we the people moment, where the people are saying that the Constitution is the Constitution because of us, the people, and since while we disagree sharply with what has happened in this particular case, then that cannot continue, and therefore he should be released from prison. But it begs the question whether the protests themselves are a clear indication of a constituent movement, where the people are rising against the government, and that type of rising up could be legitimized in due course. But I haven't seen it coming up in the papers, and I'm not sure if it will form part of the arguments that will occur tomorrow. And even if it were to, the heads of arguments that were advanced by lawyers for the commission were pretty clear to say you can't raise new issues all of a sudden that is based on no evidence, and the issues which did not appear in the papers to start with.
Thank you so much for your time and your expertise, and for sharing that with us. Advocate Mosima Rasesemola, Director at Mosima Legal and Lecturer at the Tshwane University of Technology, bringing us some legal perspective when it comes to the matter of former President Jacob Zuma. Of course, that decision from the Constitutional Court to be heard on Monday.